So today's topic is contracts for professional services. The contracting process is one of the most involved uh, things that you do between you and your client to try and establish an agreement. It is really a process of defining the project scope, time and fee, establishing and clarifying relationships, and essentially you're allocating risks and responsibilities based on what you are going to do for the project. And finally, this document will be used to confirm both parties' mutual understanding. This is an important part of your practice because if there is ever a dispute between you and your client, the third party who's going to try and resolve the dispute could be an arbitrator, could be a judge, eventually a jury, but let's hope it doesn't get to that point, will look to the contract to try to understand what both parties agree to. So it is essential that you pay close attention to what is in your agreement and try to negotiate the best agreement that you can with your client so that as a third party, essentially, would be able to understand what it is that you have agreed to between you and your client as far as the project is concerned. So to that end, let's talk about some contracts and contract law basics that you need to have in the background so that you can fulfill this role adequately. So the purpose of a contract is multifold for a design professional such as yourself. You use a contract to define the project scope, time, and fee. This is important so that both parties, both you and your client, understand what is in your agreement, what your agreed upon milestones are, and what the fee is for the services that you're providing. Essentially, you're providing these services so that you can earn money, and that is an essential part of your bargain with your client. You're also assigning responsibilities to the parties. You, as a design professional, are primarily responsible for providing consulting services to the client. Your client is responsible for paying you. Beyond that, though, there is responsibilities between you owe to your client that go to the nature of the services and what the client can expect in terms of deliverables, in terms of milestone obligations. And you're also assigning responsibilities to the owner to provide you with information about the project that maybe you can rely on. This is an affirmative responsibility that your client may owe to you, and this should be outlined in your contract. You're allocating risk according to the control, right? So depending on how much control you have over certain things, you may be willing to take on those risks. For example, the responsibility that you have to provide design services, that is, for the most part, essentially totally your responsibility because you can control that. That is what you're providing to your client. You should not be willing to take on risks for things that are outside of your control, and we'll talk about that in more detail later on. As I said at the beginning, you're documenting your mutual understanding of the relationship between you and your client, and the relationship and communication protocols between you and your client. Essentially, the relationship that you want to have with your client is one that is arm's length in nature. You are a service provider, and you are looking out for your own interests, and it is understood generally that the client is looking out for their own interests. What you don't want to delve into is establishing a relationship that implies a fiduciary obligation for you towards your client, because that implies that you are supposed to look out for the interests of the client and at the expense of your own interests. And that is generally not the relationship that you should have with your client. You're establishing an arm's length relationship where your duties are clearly defined in your agreement, and you should proceed as such. So be aware of any obligations that seem to expand that beyond that of a design professional. And during the project, you are going to have to work with your client to communicate what is going on. Design service contracts require that the owner provides input to you, that they provide the phase of your service that you're providing. For example, you may be asked to provide some preliminary solutions, some schematic designs. That needs generally to be communicated to the client, and ideally you want the client to sign off on that. That communication protocol should be outlined in your agreement so that it is clear what your responsibilities are. So what are the elements that are needed for a contract? For this to be an enforceable agreement in a court of law, you need to have these four elements. Now, for it to be a binding contract, remember that the court would look to see whether this is indeed an enforceable agreement. And if it is an enforceable agreement, a court would look to the terms of the agreement to determine if one party did not fulfill their obligations, if there is a breach in your contractual obligations. So a court would look to establish whether there is mutual assent. Generally, that is shown by an offer and acceptance. So when you are responding to a request for proposal, the client is essentially asking you to make an offer. You respond to that request, you make an offer for your services, you outline the scope, you take any exceptions that may be to the proposal, and if the client accepts your offer, then that's the acceptance. And that is indeed mutual assent between the two parties. Fairly easy to establish in a design services agreement, but realize that in order to make sure that you have that piece, it's important that you make sure that your client actually executes the agreement, meaning sign it and you sign it as well, so that you tie up the fruits of your negotiation formally. The next thing that you need to have is consideration. Something that is exchange that is of legal value. What is the bargain for exchange? In your case, you are exchanging really a set of promises. You are promising to provide design services, consulting services, and your client is promising to pay you. That is something of legal value to both parties, and so that element essentially will be met in a design services contract. The other element that a court would look to is the legal capacity to contract. Again, between two entities such as you and your client, typically a design firm and a client procuring design services, the legal capacity to contract is not really much of an issue. However, you should be aware of who in your firm has contracting authority. That should be spelled out so that it's clear who has the authority to bind your firm. And similarly, you need to make sure that the person you're negotiating with does indeed have that legal capacity to contract. And then finally, the contract itself has to be for a legally permissible objective. If it's a criminal endeavor, of course, the court would not look to enforce that. But again, for your purposes, this is not an issue. Yeah, but these are the four elements that are needed to establish a contract. So what's the contracting process like? Ideally, what you're trying to do is to assign responsibilities to a party in the best position to manage risk. So for example, construction responsibilities and site safety issues generally are not your responsibility because you do not have control over the site, over the construction, or control over the contractor's personnel to assume site safety responsibilities, right? So it doesn't make sense for a design professional to take that kind of responsibility because you're not in the best position to manage that risk. You need to have the authority to fulfill the responsibility that you have. So, for example, if you have the responsibility to look at what is the construction that has been put in place during the construction and have the authority to reject the put in place work, you need to have that authority spelled out both in your agreement and in the construction agreement between the owner and the contractor, so that it is clear who has the authority to fulfill that responsibility. And also, construction phase responsibilities and design phase responsibilities don't work well when it's being done by committee. So each responsibility should be assigned to one party. So the responsibility to schedule inspections, to schedule special things that need to happen during the construction phase, that should be assigned just to one party so that it is clear where that responsibility lies. And then finally, because so much of claims really is driven by clients who may not have had realistic expectations, is to make sure that the contract itself creates realistic expectations. There is a concern on your part that you want to distinguish yourself from your competitors and want to make representations to your client about how special you are. And that is fine, that is expected, and that is indeed a prudent thing to do. However, in your contract, you want to make sure that the language you use creates realistic expectations about what your responsibilities are, and you don't want to use vague language that could lead the client to expect that everything will be fine and that you are totally responsible for the outcome of this project. Your only responsibility is to perform the services that you've agreed to, and hopefully that has been spelled out in a manner that is realistic and makes sense to both parties involved. So some of the questions to ask yourself as you're negotiating is, what is the plain meaning of each provision? We offer a contract review service here at Schinner, and we often look at a lot of contracts, and it is not easy sometimes to understand what the language means. So anytime you look at a contract and it seems to be full of legalese, you need to step back and say, hey, if I was explaining this in plain English, what does this mean? Or what is the client trying to say? And how does that relate to my responsibilities? You should be able to explain the language using simpler language to somebody else, so that you know that you've understood the concept. If you can do that, it means that you have understood what that language means. So what is the plain meaning? And then once you understand that, you need to be able to compare it to something else so that you know what is reasonable and expected for your a design firm. So you need to know kind of what is in the AIA standard form documents, or in the EJCDC standard form documents, or if you have your own standard agreement forms, what is your preferred position? Because if you know that, then you'd be able to compare what the provision means to what is normal and try to negotiate accordingly. Are the provisions reasonable and consistent with available compensation? As I said it earlier, ultimately, you're providing services to earn a fee, and you need to ask yourself whether it is reasonable to accept the terms, and does it make sense from a business standpoint? And then do any of the provisions create obligations that are uninsurable? You know that certain of your risks have been handled by insurance, right? Your responsibility to provide services in a non-negligent manner is insurable. So if you're deemed to be negligent, your insurance policy is there to cover that. But if you've taken on a responsibility that is beyond negligence, then that is potentially uninsurable. If you do indeed want to take that type of responsibility, then you need to understand what has been handled by insurance and what has not, and then make a business decision. For you all as design firms, really, we do have a lot of claims experience, but the greatest risk, the reality is that you're not getting paid in a timely manner. So you want to pay particular attention to what your payment terms are, so that your business is essentially not lending money to your client so that they can fund their project with your fees. So you should pay particular attention to what the payment provisions are and how quickly that the client is going to pay you once you've provided the services. You should always look at what the capability of your prospective clients are, and if things have changed, maybe even your current clients are no longer able to pay you in a timely manner. As far as collection, you should always try to be as current as possible on all outstanding obligations, because if the project does not go well, then you at least have earned your fees and have collected as much of that as possible. And in the event of a claim, which is not likely, but if it happens, you don't want your outstanding fees that you've earned to be part of the negotiation in an effort to resolve that claim. So anytime that you have outstanding fees, it is your responsibility to follow up with your client and say, hey, where's my money? I've invoiced you, and follow up. Don't be shy about trying to collect money, because it does matter in the resolution of a claim if a claim is filed. So as far as the contracting process, you should pay particular attention to what your the client's payment obligations are, and make sure that it makes sense. And then after you started the project, it's on you to try to enforce the payment responsibilities. So contracts need to address all relevant aspects and unique phases of a project. So it needs to be tailored for the specific needs of a project. You want to assign risks and rewards, determine rights and responsibilities, and most importantly, establish expectations. Professional service agreements are generally divided into two categories. General terms and conditions that are important for operations and risk management. These are the terms that we review most often here at Schinnerer, because it is important that you look at what those general terms are. These terms apply to almost all of your projects, and we'll talk about these some of the general terms and conditions that apply. But you also have project-specific terms that address the particular issues of a client or a project, and that needs to be spelled out as well. Of course, the scope is generally project-specific, so that also falls into that category. But you should always look at the project-specific terms to see how this project is different from anything else that you've done before, to see if the client has any specific needs or if the project has special requirements that need to be addressed. So, at a minimum, your professional services agreement should have the following. It should identify the client and their contract authority, your scope of services and negotiated limitations on scope need to be identified. So when you're writing your scope, and that is one of the hardest things that any project manager has to do, is writing the scope, it's important to state clearly what is being provided, but just as importantly, you need to state what is not being provided so that the client, it is clear to the client exactly what you're providing. And if there's a change in the scope, as often happens once a project starts, how is that going to be reflected? How is your agreement going to be amended? What are the procedures for that? And how do you address that? It is on you, the design firm, to make sure that once you signed an agreement, started services, if there's a change, to go back to the client and make sure that that change is reflected in the formal agreement. Oftentimes what we see during a claim is that the terms were never amended to reflect the change in the scope, and that is always a much more difficult claim to defend against, as opposed to a firm that has indeed updated their agreements as change happens during the project. And finally, the amount of compensation for services. Again, remember that this is a bargain for exchange. You are providing services, they're providing you with money. That amount of compensation should be clear in the professional services agreement. So payment terms and conditions. The schedule for services and approvals. If you are providing services and the client needs to approve one phase before you move to the other, that needs to be reflected in your professional services agreement. The method to modify the schedule needs to be spelled out because milestones are important to the client, and if there's a change for any reason, that needs to be updated. The ownership and use of instruments of service, this is again an important element. This provides you with leverage as far as being able to get paid, so that if you are indeed transferring your instruments of service, make sure that none of that transfer really happens until you get paid. Insurance requirements, of course, should be included in your professional service agreements, the dispute resolution mechanism, and then finally the termination procedure. And we'll talk about these briefly later on. So the types of contracts for professional services, you should be aware that you can set up your agreement in several ways. There are generally 5 generic types of contracts: oral agreements, letter agreements, purchase orders, standard form agreements, and custom agreements. Oral agreements, believe it or not, are contracts, and it is enforceable, but there are risks to that. There are no risk management advantages to having an oral agreement with your client. And oftentimes, especially in smaller projects, you may be told to proceed, and you may proceed, but the issue becomes then, what exactly did you guys agree on? It may indicate a client's reluctance about making a commitment. So it's always vague as to what exactly is being provided for by you. We have seen these types of situations, for example, with surveyors who are doing smaller jobs, who may be asked to do a quick boundary survey for a client over the phone, identification of property, and not much more. Eventually it becomes a dispute about what exactly is being provided for, and it's not spelled out in a written agreement. Remember, as I said earlier, that with disputes, a third party will have to resolve issues about your agreement. And it is a contract, but essentially, if it's an oral agreement, it's going to be based upon conflicting testimony, because one party's recollection will be different from the other party's recollection, and even without fraudulent intent. So an oral agreement for a design firm such as yours is really of no advantage to you and could put you at serious risk in the event of a claim. So we always advocate for written agreements. You force the parties to think more carefully about your risks and rewards. You allow each party to review the terms of the agreement, and it provides an objective, documented evidence of the agreement. And that is what you need to be able to understand what both parties agreed to. Oftentimes for smaller firms, you have letter form agreements where you send out a letter to your client and you ask them to acknowledge that this is indeed the agreement. And it can be very effective if it's used with small projects that are well-defined, relatively routine scope. It can be very effective. I much prefer to using an oral agreement. Ideally, you want to reference a set of standard general conditions with that, so that it is clear what the expectations are, what the general forms are, what the payment requirements are, so that it is more robust than just the letter agreement. So letter form agreements are certainly encouraged and indeed make sense, especially when you're faced with a client who may be intimidated by a long form contract that delves into issues that may not apply or may be intimidating to a less sophisticated client. Purchase orders present challenges for design firms. It is often used to procure goods and services, and usually have other requirements that don't apply to professional services. They often contain provisions regarding warranties for equipment or warranties in regard to the services that you're providing. Oftentimes it's intended to provide warranties for equipment installers. These are really not appropriate for use in the procurement of professional services. So it can be a challenge. And so what you want to do is to be able to at least to reference the standard form agreement in the purchase order, because sometimes the client may tell you, hey, this is our procurement system. We really have no other way of doing procuring your services. We have to use a purchase order. What you want to do in that case is to at least be able to reference another form, your standard form agreement ideally, to at least recognize that you are indeed a professional performing services. Standard form agreements, these are the AIA documents, the EJCDC documents. These are, of course, ideal for you because they're well written. We think they represent a fair allocation of your duties and separate your duties and rights. The text is fairly standard, uses a language that is easily understood. They've been used now for decades, and the terms are well defined by custom and courts. And importantly, the agreements are coordinated between your professional service agreement and the construction contract agreement between the owner and the contractor. So it's clear whose responsibility it is to do certain things during the construction phase. So standard form agreements, if you're lucky enough to use them, are indeed very beneficial to firms such as yours. And even if the client amends it, it is usually fairly easy to identify what the changes are, and you can make your negotiation or your business decisions fairly easily because you know what the standard is and what the modifications are. So you should have a basic understanding of what the standard terms and agreements conditions are in the AIA or EJCDC documents, as the case may be. So remember that the modifications, though, can extend contractual obligations beyond your normal legal liability. And always pay close attention, especially if the client has amended the standard form agreement, to what the changes are, because even if it's a standard AIA document, if the changes have been made, it doesn't mean that you necessarily have the protections that are intended in the standard form agreement. So, 5 major considerations in a contract. These are basic procedures that you should be aware of as you're looking at your contract. Okay? 1, the owner requirements. What are the owner's basic requirements for the project? What is it that the client wishes to do with their money and their time? And has this been well defined? If it is fairly easy to work on developing your scope and addressing the client's needs. If not, you need to go back to your client and flesh out exactly what the requirements are. But if the requirements are indeed spelled out correctly and are well understood, it provides you with a framework for project planning and attainment of the owner's goals. And this is important for you to be able to run a profitable practice. Because if it's well understood what the client's needs are, what the owner wants to accomplish, then that really does help set you up for success. So whenever you review a contract, you need to understand, you need to be able to say, okay, do I understand what the owner requirements are? And based on that, can we proceed on negotiating our contract? The second thing that you have to examine is the scope. What is your role in fulfilling the owner's requirements? And how is that defined during the design and the construction phase? You need to be able to identify that, write that well, so that you can price your services correctly. What construction contract administration services will you be providing? How often does the client want you to be out there? This assumes that you are in a design, bid, build environment where there's a separate contract for design and a separate contract for construction, with the construction being done by an entity that you do not have a contract with, an entity that has a contract with the owner. If that is indeed the case, what is expected of you during the construction phase? Are you responding to RFIs, reviewing submittals? Are you going out on site to determine percent complete so that the owner can process payment for the contractor? Do you have the authority to review the work that has been put in place, to accept it or reject it on behalf of your client? Exactly what is it that you're doing during the construction phase, because that is a lot of times a driver for disputes is during the construction phase, when things are being put in place and it is not clear what your responsibilities are versus what the contractor's responsibilities are. If you can answer these questions clearly before beginning your project, you can properly allocate your resources and help avoid potential misunderstandings as the project moves forward. And that is essentially what you're trying to do as you review the project with your client. Compensation should be the third major consideration that you should look for. How are you going to be paid for your what is defined as your basic services? Is it on a time basis? Is it based on the completion of a phase? How often are you expected to submit invoices, and how often are you going to get paid by the client? If additional or supplemental services need to be provided, how is that going to be paid for? So your client needs to know that you're doing this for money, and some clients seem to forget that on a regular basis. Both the amount and the system and the procedures should be clearly set forth. You do not want to be in a position of trying to figure out what exactly their invoice format is after the project has started. If they have any particular requirements as to what the invoice should look like, to which billing department it goes to, ideally that should all be spelled out in the agreement that you have with your client, and should be looked at with input from your finance people, your accountant, so that it makes sense, because this is really a major area of dispute between firms and their clients. Oftentimes, it is really not the design services that is a dispute issue, it's your compensation. And often what we see are counterclaims. When a firm is trying to get paid, you file a claim to be paid, and the client often will file a counterclaim alleging that you were negligent, and that's why they didn't pay you. That may or may not be the case, but oftentimes it is a negotiation ploy to try and resolve that issue. So if you can get those terms right and make sure that you spell out what your rights are in the contract, then that helps you manage that risk going forward. The ownership of your instruments of service. This is important to define well, because who owns the instruments is an important consideration for the client. Do you own it, or does the client own it? Oftentimes what you provide to the client is a license to use these instruments, but how extensive is the license? Can they use it for repairs or other additions? What exactly are the terms of the license? And if you're transferring the license, the ownership, when does it occur? So control of the ownership of intellectual property is important because you provide services which are not really tangible. What is tangible are those instruments of your service and what can be done with them. And that should be looked at closely, because oftentimes what you're concerned about is being able to have leverage to be able to get paid. We don't see issues with drawings being used for some other purpose or being repurposed for another issue, for another project, and that leading to claims. That's really not the claim issue or the risk management issue. What is at issue is who has control, and at what point does that control transfer over to the owner. And if you want to make sure that it's important that none of that transfer happens before you get paid. Only upon payment should any licenses or ownership of your instruments of service be transferred over to the owner. The owner may want to have that ownership, and if you're okay with that, that's fine. Then make sure that it doesn't happen until you have collected all of your outstanding fees. The last major consideration is termination of services. What happens if the client decides to stop? We often get phone calls in regards to this issue. As the client decides to stop, what happens? Well, you need to look at your agreement. What are your rights if the owner wants to terminate for their convenience? And if you need to suspend or terminate, what are your rights? Because at some point, if the client has stopped paying you, you need to make a determination whether it makes sense to continue. And oftentimes that is spelled out in your agreement, especially if you're using a standard form agreement. It is very well spelled out what your rights are as to when do you suspend services, when can you terminate for failure of the owner to proceed. Your contract should definitively state each of your rights to terminate a contract, as well as the details and the process of termination. It prevents unlawful termination, and you want to be assured of protections of your rights so that you are not out money based on the client's decision to terminate. You want to, at the very least, be able to get paid for the services that you provided up to that point. That is at least something that you need to look at when you're considering contract. So we're now moving into the last phase of the presentation. Advice and questions on contractual commitments. Know your project client. Is the client the project owner, or is it an entity representing the owner of the facility? Two different profiles, two different approaches for that type of situation. If for the most part during this presentation I've assumed that the project delivery system is a design, bid, build environment. But if you are working on a design build entity, on a design build project, then your client is actually then the builder. In most cases, you're a sub to the design builder. If that's the case, you need to think about what your responsibilities are to the contractor, and what's your responsibility during the construction phase. Oftentimes, your responsibility is somewhat limited because the design builder will take responsibility for the construction activities. Do flow down provisions affect your risk? Oftentimes you may have a great agreement with your client, but if you are a sub that is beholden to a prime agreement, then you need to be aware of what those flow down provisions are and be able to make business decisions whether that makes sense for you, because at that point, oftentimes you have very limited opportunity to negotiate reasonable terms. Does the client have financial resources? This is indeed an important consideration for you. Client profiles change, client capabilities change. So you need to, especially with new clients, but even with existing clients, make sure that there are adequate financial resources to fund your project and be able to pay you as well. And really that goes not just to your fees, but also to the ability to construct the facility, because that is indeed an expensive proposition. And if the client is floundering and trying to cut costs, that could lead to problems. Does the client have the ability to modify the terms of the contract? Some entities, like public entities, for example, once the contract has been awarded, they may not be willing to amend the terms of the contract. And so it becomes difficult to adjust to any change conditions. Can the client approve progress and payment? And do they have authority to authorize additional services or change in time of performance if there are unexpected conditions during the project? You need to protect the standard of care. This has been addressed in other webinars that we've done, but you should know that you're expected to perform in a manner that meets the standard of care, broadly defined as an obligation to perform services the way another professional would have at the same time and under the same circumstances. Of course, if the contract does address the standard of care, you want to make sure that the change is reasonable and it does not introduce vague terms such as words using the highest, for example, that you will provide services in the highest possible manner. That is almost impossible to define, and it's not clear what that means. Or that it doesn't substitute a guarantee of your services or a result of the services, for example, that the facility will come in under a certain cost. You're not able to generally offer that kind of guarantee. Your obligation is really to perform your services in a manner that meets the standard of care. So anytime that the contractual obligations try to change the standard of care, you need to be aware of that and try to the extent possible, protect that standard of care so that the contractual obligation makes sense. Oftentimes, what you try to steer the client towards is to say, hey, we understand that you have particular needs, that you want a firm with particular expertise, so we will agree to perform services in a manner that a firm specializing in these types of services will do. And that is a perfectly reasonable formulation to address the client's concerns. What you want to make sure, though, is that you indeed have that expertise. If you're saying that you have specialized expertise in the services that you offer, make sure that your firm can indeed back that up and you do have that expertise. Scope of services is essential because ultimately that is what you're providing to the client, and it is on you, the design firm, to define it clearly and precisely. Are the deliverables that you're providing to the client reasonable? Does it make sense to commit to that? And will it allow the contractor, will there be enough information for the contractor to base reasonable construction bid based off of your deliverables? Does the scope extend beyond your expertise? And if so, what steps are you taking to manage that? Are you going to use a sub? Are you going to learn about that area? You need to be able to address that convincingly so that you understand that your responsibilities are being handled. I noted at the beginning that when you're writing your scope, that you should also include the things that are not being provided by you. Oftentimes that may be obvious to you, but the client may not understand what the limitations mean, the practicalities of that limitations are in the real world. So you need to go back and make sure that the client understands what that means, and if they need to address it by hiring another design professional or another firm to fill in the gaps that they may need to complete the project. And that, of course, needs to be documented so that it is understood that it is not part of your scope of services. Cost estimates are something that you need to be very aware of as far as how it's spelled out um, in your contract. You will be asked to provide opinions of what a probable construction costs are. That's certainly reasonable, but the client needs to understand that it is generally, unless you're providing those types of specialized services, that you're providing an opinion on what you think a construction cost would be for the project. It's not typically intended to be an absolute estimate. As you all know, the price of construction can fluctuate drastically. You certainly have no control over what the market conditions are. So it is an opinion and not an estimate. If the client wants more certainty, then you should encourage them to engage the services of a specialist that specializes in providing construction costs. Also, be aware that if there are any obligations on your part to redesign because the construction costs are too high, that is a business risk that you've taken on, and be cognizant of that. So if the client is trying to throw that back onto you, just be cognizant of that, and if you're willing to take it on, be aware that you maybe end up doing a redesign based on that contractual obligation. Ideally, if you have that thrown back on you, you want the client to be able to say that that is the extent of the claims that they may have against you as your obligation to redesign, and waive any other claims they may have. Be sensitive to time commitments. Time is an important thing for your client. They may have financing obligations. They may be trying to open a facility on time. But is it realistic for you? Do you have enough resources to be able to meet those milestones? And if there's an unexpected event, how does your contract handle that? What do you need to do? What are the expectations when there's a delay that is not your responsibility? Recognize vicarious and coordination liability situations. The issue is that oftentimes you have a broad scope, and there may be other consultants that the owner has hired to provide those services. If you're required to coordinate the services of others, that could be an issue for you, especially if their responsibilities are not spelled out well. If you're engaging subs yourself, realize that you have vicarious liability for their services. So it is on you to select them based on their expertise, and that you're comfortable having those types of sub-consultants under your control. You want to make sure that they have adequate insurance of their own to be able to back up the scope of services that they're providing. That is an essential risk management tool that you want to be able to implement as far as subs are concerned. Or you may require contractual indemnity, but realize that if they don't have assets, that really does not provide you with much protection at all. So ideally, you want to make sure that they have adequate insurance and have the necessary expertise. Be aware of selecting subs that have been selected by the client for you, because unless you're comfortable proceeding with that, you may be engaging a consultant who's not really qualified to perform the services. So it's on you to make sure that you're comfortable with all of your subs. We talked about the value of owning your design deliverables. Make sure that you receive payment before sharing the instruments of your professional services. And if they want ownership, are you willing to change the licensing provision? Does the copyright go along with the deliverables? And can the client agree to indemnify you for modifications of your deliverables once they've been delivered to them? So that ideally you want them to be able to say, hey, if there's any issues that arise because others have modified these documents or we have and we've used them in another way, we will indemnify you for any claims that may arise from that. Be aware of insurance requirements that the client may be imposing on you. Do you have the standard coverages? This is something that you will need to discuss with your insurance advisor because this can change fairly quickly. Are the limits being asked of you reasonable? Is there a requirement that you continue coverage for a certain number of years? Are there notice requirements that are not attainable? Again, these are things that you need to address in your contract in consultation with your insurance advisor. As far as indemnity, a lot of time is spent negotiating indemnity provisions. It's important that you review these carefully. Is it extend beyond your negligence? Does it include an obligation to provide a defense to your client? These are items that may not be covered by your insurance. And to the extent possible, does your client agree to indemnify you for harm that it or its providers may do to you? So it's important that you address contractual indemnity provisions to make sure that these are indeed reasonable and within the scope of coverage of your professional liability policy. This is probably the most underrated part of limiting risk, is limiting liability for consequential damages. All of the standard form agreements have this as a standard provision. If you have this is an important limitation because you want to be responsible for any direct damages that the client has due to your negligence. The consequential damages piece, although it may be covered by your insurance, realize that the scope of these damages could be very much higher. If you're looking at delay damages because a certain facility is not open on time, and it is, if that type of damages have not been waived, it could increase the damages that you're responsible for significantly. So if the client is not willing to limit your liability for consequential damages, does it make sense for you to accept that? It's a risk-reward mechanism. Does the compensation make sense? Does it make sense to accept that kind of additional exposure? And also, if you have subs, make sure that they have the same terms that you have with your client, and that you're not agreeing to limit their liability for consequential damages when in reality you do not have that protection from your client. You want to preserve your rights in suspension or termination situations. Do you have the right to suspend services? Do you have the right to interruption costs if you have to suspend your services? If the client decides to terminate for their convenience, what exactly are your rights? Can you be paid for services and costs? Can you collect lost profits? There is an argument to be made that you have foregone other opportunities in order to pursue this project with your client, and therefore you're entitled to lost profits. Some clients may agree, some may not, but it's certainly an argument that needs to be made. And can you negotiate for use of deliverables if they decide to terminate your services? What do they want to do with the deliverables you've worked on today? Limit responsibility for construction site safety. Again, this is a fairly typical requirement in your standard form agreements, and make sure that you do not accept site safety responsibility, that is solely on the responsibility of the contractor. The resolution of disputes, is that addressed in your agreement? You want to make sure that your client, I apologize, the slides keep skipping forward, that the client does not have the ability to unilaterally withhold payment for services that are not subject to a dispute. You should be able to collect payment on the services that you provided to date. If there's a dispute, then that should be kept separate from your right to collect payment. Also, make sure that you do not have a prevailing party fee collection provision that could be business risk that you take on that may not work out and could be outside of your insurance. So, your agreement should have commitments that are well planned, realistic, and operational. It should be reached efficiently. You shouldn't have to spend inordinate amounts of time negotiating with your client. You should serve as a project management guide. Your project managers should certainly know what is in the contract as they manage the project. It provides for effective communication, and you're building a good working relationship between you and your client. Claims, in our experience, really come about often because you have lost that good working relationship with your client. So a reasonable contracting process should establish a good working relationship between you and your client. And that brings us to the end of our presentation. I just wanted to urge you to visit our website. Here's a look at our new website. It's been recently revamped. If you have not already established an account, you really should do so. Once you register, you can view claim studies, practice management information, contract language, and commentary, and past webinars, which can now provide continuing education units and much, much more.